Draft Scotland Act 1998, Modification Schedule 5, Order 2026.
Before I call the Minister, can I just maybe be helpful to members, right honourable members, to say this is not a general debate on assisted dying, and I will not allow debate on that context. The institution is very clear. It's a draft order that provides a narrow exception to reserve matters to enable the bill to completely confer powers and respect, etc., etc. So you must stick to the instruments here today. So I'll not accept a debate widening onto the issue of assisted dying. Minister.
Thank you, Chair, and it's a pleasure to serve under your chairship. I beg to move that the committee has considered the Draft Scotland Act 1998 modification of Schedule 5, Order 2026, laid before this House on the 17th of December 2025. As with all the Scotland Act orders we have considered since the start of this Parliament, this is a result of close collaborative working between the UK and Scottish Governments. The order before us will be made under Section 30 of the Scotland Act 1998, which provides the power for the legislative competence of the Scottish Parliament to be altered. Specifically, it enables modifications to be made to Schedule 4 or Schedule 5 of the Scotland Act 1998. Orders made under this provision are subject to the affirmative procedure in both the UK and Scottish Parliament. The order was considered by the Scottish Parliament, having been considered by the Health and Social Care Committee. The order will also be considered in the other place. Turning now to the purpose of the order. The Assisted Dying for Terminally Ill Adults Scotland Bill, a Members' Bill introduced by Liam MacArthur MSP, is currently before the Scottish Parliament and seeks to create an assisted dying regime in Scotland. I'm acutely aware of the sincerely and strongly held views on the topic, and I would like to emphasise that the UK Government is neutral on the matter of assisted dying. It is a matter for MSPs in the Scottish Parliament to determine whether there should be an assisted dying regime in Scotland. The Scottish Government identified areas of this bill as being outside of legislative competence and as such requested a Section 30 Scotland Act order from the UK Government in respect of substances and medical devices, as they consider that such provisions are fundamental to the operability of the bill. The UK Government considered the request carefully and, following engagement with the Scottish Government, concluded that making a narrow, time-limited Section 30 order would be the most appropriate action. This approach enables members of the Scottish Parliament to consider the bill in the Scottish Parliament with clarity as to how the matter of substances and devices which may be used for an assisted dying regime in Scotland could be dealt with, while protecting reserved matters such as medicine regulation. And so I want to emphasise that this is a limited and temporary change to the Scotland Act 1998. If I may explain the time-limited nature of this order further, this Section 30 is time-limited so as to reflect the circumstances of the Scottish Parliament Bill and the upcoming Scottish elections in May. The time-limited nature of the order reflects that, firstly, this is not a fundamental or permanent alteration to the devolution settlement, and secondly, that it would not be appropriate to preempt consideration by a future Scottish Parliament. This time limit applies to the legislative competence of the Scottish Parliament, but this will not affect the future exercise of any regulation-making functions conferred by the bill beyond the 7th of May 2026, should the Scottish Parliament determine to do so. The order has been specifically designed to ensure that the Scottish Parliament can create an overall framework for medicines and devices to be used in an assisted dying regime, should they decide to do so. I would particularly like to take this opportunity to thank members of the Scottish Affairs Committee for their carefully considered report on the SI. On the question of whether the Scottish Parliament would be able to amend or repeal the Act's regulation-making powers in a future Scottish parliamentary session if the bill is passed and contains regulation-making powers authorised by Section 30 order, it would not be possible for the Scottish Parliament to amend or repeal those regulation-making powers in a future session. The time limits within the Section 30 order mean that this would no longer be within the Scottish Parliament's legislative competence to do. Subject to the Secretary of State's approval, they would instead be able to revoke or amend the regulations that had been made under those powers. I'm aware that the content of this order has prompted queries about the approach the Government has taken. Firstly, around why the Government has taken forward a Section 30 order and not, for example, a Section 104 order. Secondly, on the scope of this order and the matters which are not included. And thirdly, on the likelihood of other orders being brought forward under the Scotland Act 1998. The committees who scrutinised the order, as well as the consideration by the Scottish Affairs Committee, both of whom raised these points, and so I would like to take the opportunity to thank them for the scrutiny and provide answers. They are as follows. The Government considers all requests for Scotland Act orders carefully and looks at what, if any, provisions made under the Scotland Act 1998 may be appropriate. This includes Section 104 of the Scotland Act 1998. Section 104 is routinely used to make provision in consequence of an Act of the Scottish Parliament, that is to say, once a bill has royal assent. In this instance, it was not considered an appropriate option due to the limitations of the power. Section 104 cannot be used before a bill achieves royal assent. The request was to take action before, and the Scottish Government's view that the provisions were fundamental to the operation of the bill. Moreover, Section 104 cannot be used to create regulation-making functions. Section 30 was considered appropriate as it enables the Scottish Parliament to introduce regulation-making powers within the narrow scope of the order. So, in essence, Section 30 was in this instance the only means of achieving both of these outcomes. The Government therefore believes its approach is appropriate in the circumstances. On the second point, the Government has been asked why the order does not include further subject areas that the Scottish Government has identified as being outside competence. The Government's view is consistent. It's a matter for the Scottish Parliament to ensure legislation is within competence. While Section 30 orders have been used occasionally in the past as bills have proceeded through the Scottish Parliament, it is not a regular practice, nor would be expected to be. We have agreed to it in these circumstances. Consequential legislation is, however, routinely taken forward and is rightly considered by this House. Such consequential orders cover matters that cannot be legislated for by the Scottish Parliament. The Scottish Government asked the UK Government to consider Section 104 orders in relation to professional regulation and opt-in measures, and subsequently if the UK Government will consider a Section 30 in respect of these provisions. The UK Government's position is that consequential legislation is the appropriate means of addressing or considering reserved provisions. Fundamentally, the Government is not seeking to substantially alter the devolution settlement via this order. Therefore, it is appropriate that the order was narrow and addressed the key questions asked of it. Ministerial correspondence has confirmed the Scottish Government were seeking agreement to a Section 30 order on the narrow scope of substances and devices, with further consideration to be given to Section 104 orders. The UK Government has agreed to further requests in consequential legislation, as is a normal occurrence. Of course, the order before the committee today is the order the Government has agreed to take forward with the Scottish Government on the matter of substances and devices. That is the matter that the Government is seeking the approval of the committee for. Both governments agree that the specification of substances and devices, as well as their associated regulation, is fundamental to the operation of the Scottish Parliament Bill and the workability of the assisted dying regime which the Bill seeks to introduce. So, let me end by reiterating. The UK Government maintains its neutral stance on assisted dying and does not endorse any particular outcome of the consideration of the Bill before the Scottish Parliament. I do recognise that there is interest in the existence of schemes across the UK in view of the legislation being considered by the Scottish and UK Parliaments. I would state that the position is not changed by this order. The order has been specifically designed to ensure that the Scottish Parliament can create an overall framework for medicines and devices to be used in an assisted dying regime, should they choose to do so. Thank you.
The question is that the committee has considered the Draft Scotland Act 1998 modification of Schedule 5 Order 2026. I call the Shadow Minister.
Thank you, Mr. Twigg. It's a pleasure to serve under your chairmanship this afternoon. I must start by saying it's rather odd this afternoon to stand in front of this delegated legislation committee pertaining to a piece of legislation which is significant to the functioning of the devolution settlement and will affect constituents of mine, my friend the Honourable Member for Gordons, my friend a member from Dumfries, and to see such a lack of attendance from Scottish Labour MPs in the room, with the notable exception of the member for Central Ayrshire and the chairman of the Select Committee, who's here in her capacity, I believe, as the chairman of the Select Committee, and not here to vote on this. And I was going to begin my contribution this afternoon by asking why the government had not taken up the advice of the Select Committee to have this debate on the floor of the House. I do wonder if the absence, or even of the Scotland Office Whip from this debate this afternoon, if we could read into that some lack of support from Scottish Labour MPs for the decision being taken by the government this afternoon, or if the government is worried about getting this through, because it does speak to, I think, a lack of respect to Scots who will be affected by this change, that a government with 37 members of Parliament who represent seats north of the border couldn't muster up more than one to sit on this incredibly significant committee representing constituencies who will be affected by this order. I would hasten to suggest that even in our diminished capacity in the last Parliament of having only 6 MPs on the government side from north of the border, we would have been able to muster up more than one to sit on the backbenches of such an important committee when it comes to changing legislation that has a direct impact on the lives of Scots. So I do wonder whether the government might want to think about what this represents and how this looks to many Scots who will be looking on at this, wondering where their representatives are, given that this pertains directly on their lives and how we move forward in terms of governing the very important issue of how assisted dying is legislated for and regulated for within this United Kingdom. That's a question for the government to examine their own consciences of. As the Chair has said, this is not a debate about the merits of the assisted dying bill being considered by colleagues in the Scottish Parliament, nor indeed the bill going through its stages in the other place here in the Palace of Westminster. There will be strong, impassioned views on both sides on that wider debate here, but the progress of that private member's bill in Holyrood is a matter for our members of the Scottish Parliament and is a conscience issue for my party and others. The matter before us today is not the political context of the instrument, but the modification order itself, its competence, the precedent it establishes, and its consequences. And so I must say that His Majesty's opposition have grave concerns on the implications of this instrument. This instrument invokes the powers granted under Section 30 of the Scotland Act 1998 to alter the devolution settlement, granting the Scottish Parliament new powers to legislate on medicines, medical supplies and poisons, which would otherwise be a reserved competency. Let us be clear. This is a novel and in some ways unprecedented circumstance. Use of this mechanism to amend the devolution settlement is rare. The last application was in 2012, enabling the Scottish Government to hold the 2014 independence referendum. This came about as a result of months of discussion ending in the Edinburgh Agreement signed by both Scottish and British governments. And it is unprecedented insofar as it makes provisions to enable the consideration of legislation which is not Scottish Government-sponsored legislation, but a private member's bill. The Assisted Dying Bill, under consideration in the Scottish Parliament, would, in Section 15, give Scottish ministers the power to specify the drugs or medication to be used to assist a patient to die, which, as it stands, is within the reserved competency of medicines, medical supplies and poisons. The private member's bill currently under discussion in the Scottish Parliament requires clarity on this issue and a raft of other reserved competencies, which it is entirely unclear how the government intends to resolve, hence the attempt, this modification order, to tread a middle ground with a time-limited provision, as the Minister has set out. It is clear that the regulation of medicines issue is indeed integral to the MSP's consideration of the debate on assisted dying. However, this legislation seems to be a leap ahead into a hypothetical position. It lays the foundations for the implementation of a bill which the Scottish Government and the UK Government are neutral to, which is not government-sponsored legislation, given that the PMB is still underway in the Scottish Parliament, and since there remain further steps required if the Assisted Dying Bill is to sit within the Scottish Parliament's legislative competence. It seems a very strange sequencing of events to preemptively order the limited devolution of such powers to provide for the circumstances where the bill were to pass in Scotland. Secondly, I come to a point on accountability. In Schedule 4A, yes, of course, I'm delighted.
Always enjoying the Honourable Gentleman's comments. I just thought he was going to offer a solution, if not a Section 30 order, in order for this bill to be considered. What would he propose we should do?
Well, I think that it's the hypothetical nature of this order with which we hold such an issue. If this bill was to pass, it should then be for the UK Government to determine how we facilitate the devolution of such powers so as to make it legal and competent within the Scottish Government's purview. But it's not, I don't think, the right step to preemptively devolve power ahead of a bill being passed. That, I am afraid, runs the risk of setting a dangerous precedent for other issues and items which may come about as a result of the private member's bill process in the Scottish Parliament, not least maybe some other discussion around issues pertaining to the Constitution, which I'm sure was not what the Right Honourable Member was referring to in any way. And I would like to come to a point on accountability. In Schedule 4A of the Order, subsection 1, it outlines a scenario in which powers can be conferred on Scottish ministers to use subordinate legislation to identify the relevant medicines, medical supplies and poison, subject to the approval by the Secretary of State. Subsection 2 provides for the conferral of power to the Secretary of State for the regulation of such medicines. In either case, the Secretary of State retains a veto power over the regulation of medicines. The Scottish Government would not truly be accountable for the implementation, and the Secretary of State does not directly influence Scottish Parliament bills. I understand the Minister's argument regarding the coherent regulation of substances across the United Kingdom and the implications for the MHRA, but does the Minister foresee any incompatibility between the consistent regulation of substances across the UK and the effectiveness of implementation of any assisted dying subordinate legislation which would identify medicines to be used for that purpose. Section 30 orders have never previously been used to confer powers directly on a British government minister. The precedent this order establishes is one of piecemeal devolution and disintegration. Furthermore, the veto power conferred upon the Secretary of State and the resultant confusion in terms of authority and accountability is an unprecedented power-sharing layout representing a departure from the constitutional norm we have had since 1999. Now, we are absolutely not against the sovereign government of the United Kingdom taking an increasingly active and interested role in the governance of Scotland. But this is not the mechanism and not the way to go about having this conversation. Indeed, it is yet another reason why this debate should be taking place on the floor of the House of Commons and not in a committee room at 2:30 on a busy afternoon with no Scottish representation, bar one. Moreover, this limited approach does not resolve the remaining inconsistencies which we would face should the Scottish Parliament's assisted dying bill pass, for example, regulation of medical provisions and employment and industrial relations. There are significant concerns over the mechanisms which might be invoked to remedy the remaining competency challenges, namely through the Section 104 order. This question goes to the heart of the issues surrounding devolution and Scottish Parliament competence. While we have consensus across the House that the issue of conscience regarding assisted dying in Scotland is now one for MSPs in Holyrood to decide upon, I cannot help but reflect on the truly disjointed situation in the United Kingdom that we may land ourselves in if the bill is passed in Scotland while defeated in England and Wales. What will the Minister and his Cabinet colleagues do in that situation? So I'd like to ask the Minister, on that point, how they intend to preserve unity in the medical profession across the United Kingdom. How do they intend to preserve uniformity for those who conscientiously object within the medical profession more broadly? What was the reasoning behind selecting a Section 30 order over a Section 63 order? And do they have any concerns regarding the use of the Section 104 order to resolve the remaining litany of inconsistencies which are not broached by this modification order? Mr Twigg, we will be voting against this mechanism today for the reasons that I have set out. And I once again must put on record my dissatisfaction and the dissatisfaction of the official opposition that this incredibly sensitive and significant debate is taking place with very little interest or representation from Scottish Labour MPs, and indeed is not being given time on the floor of the House.
Patricia Ferguson, Chair of the Scottish Charitable Section. Sorry, repeat. Sorry, Pete Sharp first, sorry.
Thank you ever so much, Mr Twiggin. It is a pleasure to serve under your chairing this afternoon. I rise, of course, to support this order, and I'm grateful that the Scottish Parliament, if this is passed, will now be able to consider the Scottish Assisted Dying Bill without concerns about legislative competence. And I'm utterly amazed to hear the Honourable Gentleman saying His Majesty's opposition are going to be voting this down without any solution about how the Scottish Bill will be able to progress without this order being passed. So I would urge honourable gentlemen and ladies in this room today to support this and ensure that we get this opportunity, just like that has been in Westminster, to consider moral conscience when it comes to the decision about assisted dying in Scotland. And I find it astounding that they're going to be voting against it. I'm going to get an explanation from the honourable gentleman now.
Thank you very much for giving way. The position he's put forward is that we would somehow stop the assisted dying bill progressing in Holyrood. That's simply not the case. There's a date set, I believe, in Holyrood for this to be further discussed. We are putting the cart before the horse here because we are being asked here to make provision for a bill which might or might not see the light of day. It seems a very peculiar situation, and there is also the danger as well of the precedent that's being set here, because this is a private member's bill. This system has never been used for a private member's bill before, and a dangerous precedent could be set there.
I always enjoy the honourable gentleman's words of wisdom, so very tempted maybe just to respond to this. And I'll just set out the sort of conditions of what's required in order for the Scottish Bill to progress. The Scottish Bill cannot progress unless we have the devolution of poisons. I don't know if the honourable gentleman's aware, but if we're talking about the assisted dying, there has to be an end product at the end of it with somebody dying, and the only way this is going to be done is through us having the opportunity to use the poisons which are currently reserved to Westminster. So I don't know what proposal he's got in order for that to actually take place. And how can a Scottish bill go forward in the Scottish Parliament without the comfort that it will be within devolved responsibility and that they will be competent to make a decision. It is an absurd position by the Scottish Conservatives, and I cannot believe that they have come here today with this attitude and approach in mind. And I ask them to reconsider this, because we need, just like this place has the opportunity to consider this bill, we need in Scotland the opportunity to look at this. This is an important issue that should not just be confined to this House, and I really hope the Scottish Conservatives think about this again. But in saying that, Mr Twigg, I do find this a curious and convoluted piece of parliamentary procedure which seems to be unnecessarily excessive and totally cumbersome given the issues involved. And once again, it's a Section 30 order that's been used as the main means to allow the Scottish Parliament to legislate if required. But if this bill is passed, I think, and I was listening very carefully to the Minister's comments, I think it's to be accompanied by a Section 104 order if the bill is passed, in order to devolve further specific identified provisions. I sort of heard her saying that there would be a Section 104, and then I sort of heard her say too that there wouldn't be a Section 104, so I think she has to clarify for all the other outstanding issues beyond the use and resourcing of poisons and medicines, how the government intends to allow the comfort that the Scottish Parliament bill could proceed, and what they would do if that bill is passed. The Section 104 is an obvious means and mechanism to achieve that, so I hope that's exactly what she's going to tell me when she does wind up in her remarks. Now, I've been in this place for 25 years, Mr Twigg. I know you can't believe it, looking at this youthful member of Parliament in these benches. But in that time, in my time in Parliament, I think I've seen some 15 or so Section 30 orders issued. Most of them, the most notable being, of course, as been mentioned, was the Section 30 order through the Edinburgh Agreement to devolve temporarily the rights of the Scottish Parliament to hold devolved competence, so it could obviously have the independence referendum on Scottish independence. None of them have been accompanied by any other associated orders, and none other than the order for the referendum has been issued with a sunset clause. So this is totally unusual in this respect, that we have a time-limited devolution Section 30 order with a sunset clause which is going to be in the face of this order. And as the Minister says, there are 3 areas I think have been identified where the proposed legislation the Scottish Parliament strays into reserve responsibility. The main one has been outlined by the Minister, being relevant to provisions which involve medicines, medical supplies and poisons. Resources, as I've just said to my honourable friends, the Conservatives, which would be absolutely necessary if a terminally ill person has asked for assistance to die. And I think, firstly, there will be general mystification in Scotland that in a fully devolved health service, that these vital responsibilities and resources remain held by Westminster. I think the Minister will have to explain to us properly why, given that we're responsible for practically everything else to do with our National Health Service, as is right and proper in devolved Scotland, that these aren't properly devolved. And if I was going to suggest anything to the Minister, it would be to use this opportunity to make these powers permanent, so that we could properly resource and equip our NHS to do the job that it requires. And I'm seeing grumbles of complaints from my colleagues across the bench, but I do not understand for a minute why the Scottish Parliament could not have these powers, just like the NHS in England has, and why is that the case, that this is the state of play just now. Now, the other issues are less clear, but apparently may stray into the regulation of health provisions and employment and industrial relations reservations. This is mainly, I believe, and I think it would require some further clarity about this. This is to do with matters of conscience, but I think they do require a further explanation about how this impacts on what are considered to be reserved regulations, because I think there was great confusion in the Scottish Parliament that this was going to be the case. And it's certainly the case, Mr Twigg, that Liam MacArthur and the supporters of his bill in the Scottish Parliament had absolutely no idea when they were presenting this bill to the Scottish Parliament that any of this strayed into reserved responsibilities. And I think it came as a great surprise that this was in fact the case. And it's only when Scottish Government lawyers had a look at the bill, as is their right and as is the right thing to do, that they discovered that there were indeed issues to do with reservations. And I'm really grateful that they had that look in order that we could try and get this issue resolved. These responsibilities then, as we've heard, will now be devolved through Section 30, but only until this Parliament is dissolved. Now, this time window is designed to allow the Scottish Parliament to consider this bill and pass it if agreed. But why not, as I've said to the Minister, give these responsibilities to the Scottish Parliament without time limit? Now, there's only a matter, I think, of 6 weeks until the Scottish Parliament is dissolved for the next Scottish general election. And there are questions whether there will be enough time for this bill to be considered properly. It's at least the case that it's likely or possible that the next Parliament will want to revisit this as an issue and a debate, and I'm pretty certain that there will be some private member that will be very keen to bring this through if there's been no opportunity to conclude the consideration of the assisted dying bill as it currently stands in Parliament. But the second issue that concerns me is that these delegated powers can only be exercised with the Secretary of State's agreement. Effectively, Mr Trigg, what this does is to give a veto to the Secretary of State for Scotland for powers that will rightly be temporarily devolved to the Scottish Parliament. Again, I've never seen anything quite like that in all of the 15 or 16 Section 30 orders that have been put through this House, and I think we need a proper explanation about why that's the case. And regardless of the fact that most Scottish MPs for some reason have opted to exercise their right to a conscience vote in this House on an England and Wales only bill that has absolutely no impact on their constituencies. The Scottish Government has rightly no say whatsoever on the English bill. So why should Westminster have the last words on the provisions in the Scottish bills? And I think we need a proper explanation for that one. So, Mr Trigg, I will support this order. I encourage colleagues to do this. I'm utterly flummoxed by the position of the Scottish Conservatives, but we do have issues about this. And the thing that I would agree with the honourable gentleman is this should have been conducted on the floor of the House of Commons. There are huge and massive questions and issues for the devolved settlement, and I really wish that the Minister had decided to do that, and I think that was one of the recommendations that was in the Honourable Lady's report, and it's something that should have happened, but I'd be grateful to the answer to these questions that I've laid forward to the Minister this afternoon. Thank you.
Susan Murray.
Thank you very much, Mr Twigg. It's an honour to serve under your chairship. For Liberal Democrats, this is also a conscience vote, and within the limitations and the context laid out in this order, we would just say that we would support. Thank you.
Right, Patricia Ferguson, Chair of the Scottish Affairs Committee.
Thank you, Mr Twigg, and it's a pleasure to serve under your chairmanship. Instruments such as this draft order alter Scotland's devolution settlement and require intergovernmental cooperation. Both of those areas fall squarely within the Scottish Affairs Committee's remit, and it is for those reasons that, as members of this committee will be aware, the Scottish Affairs Committee has scrutinised this draft order. We published a report to aid Parliament's consideration of this instrument. And I should put on record that I'm grateful to the Scotland Office for their engagement with us, and our correspondence with them about this order is of course published on our website. I would also like to make it clear that as a committee we remain neutral on the issue of assisted dying. Our report does not comment on the substance of this sensitive matter, but does draw Parliament's attention to some of the unusual features of this draft order. Given the relative rarity of Section 30 orders, our interest relates to its legal and constitutional implications. In my remarks today, I will give an overview of these issues. First, though, Mr Twigg, I'd like to take this opportunity to also express my gratitude to my fellow committee members, some of whom are here today, for their thoughtful consideration of these issues. This statutory instrument would use powers under the Scotland Act to extend, in a narrow and time-limited way, the Scottish Parliament's lawmaking powers. It does this to enable the Assisted Dying for Terminally Ill Adults Scotland Bill to become law, if the Scottish Parliament so decides. During the bill's scrutiny stages in the Scottish Parliament, the Scottish Government identified 3 areas which relate to reserved matters under the Scotland Act. If the UK Parliament does not take legislative action, the bill as it currently stands would be outside the Scottish Government's competence. The specific way in which these issues are being resolved through this order gives rise to 3 observations which I would like to draw to the committee's attention today. Firstly, the governments have adopted a 2-stage bifurcated approach to address the 3 competence issues. This draft Section 30 order will only resolve the issues related to the regulation of medicines and medical devices. The other 2 outstanding competence issues relating to the regulation of medical professions and employment and industrial relations are expected to be resolved via a Section 104 order. A Section 104 order would make consequential provision after the bill receives royal assent. This requires the relevant provisions to be removed from the bill before it is passed by MSPs. We asked the UK Government why it has adopted this 2-stage approach rather than addressing all the competence issues in one go. In response, the Government said its approach would allow the Scottish Parliament to debate with clarity how the bill's core issues will be handled, rather than issues that might arise as a consequence. It also said Section 104 cannot be used to confer powers to make subordinate legislation, which the bill's provision on substances and devices for assisted dying would require. This explains why not all issues were dealt with using a Section 104 order, but it does not explain why some issues are being dealt with by a Section 104 order rather than this Section 30 order. And our report highlighted that this approach has implications for effective scrutiny. In particular, it means that while the Scottish Parliament will have clarity over how issues relating to substances and devices will be handled, there will be no such clarity in respect of the other 2 competency issues. The Scottish Government has already indicated that some provisions will need to be removed from the bill before the final Stage 3 vote. It would not be possible for MSPs to assess the Section 104 order, which will be used to fill the legislative gaps before the bill is passed. Our report suggested that any uncertainty could be remedied by the UK Government publishing its Section 104 order in draft before the Scottish Parliament's Stage 3 consideration. Given the draft's constitutional significance, we also recommended that the instrument should be debated on the floor of the House, rather than in a delegated legislation committee. And I note that this approach has been taken in the other place. However, members will know that this recommendation was not adopted by the Government, which is disappointing. And on that point, can I take this opportunity to gently highlight to the Minister that it might have been courteous and helpful for the Department to have written to my committee before this delegated legislation committee was scheduled to respond to that specific and time-sensitive recommendation. Our report also casts light on the ongoing role retained by UK ministers within this draft order. The manner in which the draft order confers powers relating to medicines and devices means these powers are only nominally transferred to the Scottish Parliament. The Secretary of State will retain the ultimate say over how those powers are used. It is clear this approach has been agreed by both governments. However, our report highlighted that it is a novel, though perhaps not unprecedented, approach. The default approach is that when a matter has been devolved, the Scottish Parliament confers powers on Scottish ministers who are then answerable to the Scottish Parliament. However, this Section 30 order envisages that some regulations resulting from the Act could be made by a UK Government minister acting alone. Those regulations would not be subject to scrutiny by MSPs. This approach is unusual, as the Scottish Parliament does not normally confer powers on UK ministers. In her response, could I ask the Minister to clarify how the remaining competence issues will be resolved, and what consideration the Government has given to implications for effective scrutiny. Finally, Mr Twigg, our report draws special attention to the time-limited nature of the draft order. While time-limiting a Section 30 order is not in itself new, this one is slightly different. The powers this order would confer would effectively expire if the current bill does not complete its final stages before the Scottish Parliament elections this year. When questioned on this approach, the UK Government confirmed it is only willing to devolve competence in respect of the specific bill currently under consideration. However, what is less clear is how the time limit would affect subsequent amendments to the primary legislation further down the line. For example, if the Scottish Parliament wished to change the regulation-making powers of the Act. In the Minister's response, I hope that for the benefit of this committee, she will outline whether the Scottish Parliament would be able to amend or repeal the Act's regulation-making powers in a future Scottish parliamentary session. In closing, the draft order before us has important constitutional implications. It is right that these issues have been properly scrutinised, and I hope that the Scottish Affairs Committee's report will be useful to the committee and to the wider House. I know that the Department has responded to the committee's report, and this response will be considered by the committee at our meeting tomorrow. We will make every effort to ensure that response is published before the House votes on this instrument. In her reply, I look forward to the Minister's response to the points I have highlighted, particularly regarding the need for clarity on any forthcoming Section 104 orders, the novel role for UK ministers, and the implications of the proposed time limit. Thank you, Mr Twigg.
Minister.
Thank you, and I would like to thank honourable members for their contributions and consideration today, and I hope to cover all the points raised by honourable members in turn. So if I begin with reflections from the honourable member for West Aberdeenshire and Kincardine, who asked why this debate was not conducted on the floor of the Commons. As he will know, because we've sat opposite each other in this space many times, Scotland Act orders are generally considered in Delegated Legislation Committee and subsequently by a motion put to the House, so this is entirely in keeping with normal practice. The honourable member for Perth and Kinross has asked for clarification of the UK Government's role and indeed a justification for that in medicines regulation. Well, the UK Government's role in medicines regulation is to set and oversee the UK-wide statutory framework that ensures licensed medicines are safe, effective and of high quality before they can be supplied to patients, and it's critical in our view that regulatory consistency is maintained across the UK. It's been a key priority post the EU exit, and we have prioritised avoiding any divergence between regulatory approaches. So the limited nature of this change will ensure that the overall integrity of the UK-wide medicine regime is retained, whether or not the Scottish Parliament approves of the MacArthur Bill. Now, in line with that line of questioning, the honourable member for Perth and Kinross asked why the Secretary of State will continue to have the final say over how that power is used. The order's change to legislative competence is specifically designed to allow for that to be retained, because we do think the UK Government has an appropriate role in the overarching regulation of medicines across the UK, which is why it is and will remain reserved. However, we do want to enable the Scottish Parliament to introduce provisions that could confer power in this way, in a way that simultaneously maintains the integrity of the UK medicines regime and allows the Scottish Parliament to debate that which is legitimately inside their competence. So the order... Yes, I will.
He was
yes, it's absolutely right that the Scotland Office have an appropriate role, but to have the final say, I think, is actually quite different to anything we consider with Section 34. And she's not given any explanation of why that is actually required.
Chair, so it is both required and desirable because we believe there should be integrity of the medicines regulatory regime across the United Kingdom, but we're trying to strike a balance where we do want to give the Scottish Parliament the ability to confer the power to Scottish ministers to identify, in this case and only in this case, that substances and devices that could be used in assisted dying are able to do so if that's the will of the Scottish Parliament, provided, of course, that that's done by way of subordinate legislation made with the agreement of the Secretary of State. The provisions in this order also provide that the Scottish Parliament may confer powers on the Secretary of State to regulate such substances and devices by subordinate legislation. In our view, they are separate matters, and we're trying to find a balance between the two. Turning to the questions raised by the Chair of the Scottish Affairs Committee.
The Honourable Lady give way.
Let me just put on record my great thanks to the Chair and the Committee for their scrutiny, and I hope I'll cover all the points that she's raised in turn. Please.
Thank you very much, Mr Twiggett. I would also like to put on record my thanks for the committee and the role they have played in providing scrutiny to this draft statutory instrument that is before us today. The Minister hasn't explained just why there are so few Scottish Labour MPs in the room this afternoon. It was a question I asked at the very beginning and indeed asked thrice through my comments. It cannot be surely that aside from the Honourable Member and the Minister, there's a lack of interest in the statutory instrument, given the important implications of this bill in terms of how law is delivered in Scotland. So might the Minister provide an explanation?
So, as we're about to cover in answer to a number of questions, the provisions in this order are actually incredibly narrow and incredibly time limited. It's appropriate that it's done in a delegated legislative environment, and members of the House are doing all manner of the House's business and indeed the business of their constituents. Now, if I could just turn to...
Would the Honourable Lady give way? I'm very grateful to her. She's been very generous with her time. I have been through a number of, as the Minister referenced herself, a number of these committees with the Minister on this side and indeed on the other side of these committee rooms. It has never been the case that all but one of the government benches have been from areas outside Scotland when we're considering amendments to the Scotland Act 1999. Surely she doesn't expect us to believe that 35 Scottish Labour MPs are so busy that they couldn't find time to come along to debate this important issue in front of us today.
Mr Chair, I'm here to lay out the Government's view on this Scotland Act order. I'm not the Diary Secretary for my colleagues. I don't think he'd expect me to be. We're here to debate this order. Now, the Chair of the Scottish Affairs Committee and indeed other members of the committee today have raised repeatedly a question which I hope I addressed in my opening remarks, but let me reiterate the view about why a Section 30 and not a Section 104 order is the appropriate way to get done what we need to get done today, and it's for two reasons. That a Section 104 order cannot be invoked until a bill has had royal assent. It simply can't be, and likewise it cannot be used to confer regulatory powers, which is specifically what the Scottish Government asked for in the intergovernmental conversations that we had. The Scottish Government have noted that the details of what a future Section 104 order might contain are still being worked through. So it would not be possible for us to say in advance what our response to a request for a Section 104 order would be, because no such request has been forthcoming. But to clarify for the committee, in correspondence to the Scottish Parliament, the Scottish Government themselves have stated it is likely that some, if not all, of the relevant provisions will need to be handled through a Section 104 order, which, as outlined previously, will mean that they need to be removed from the bill to be dealt with in that way. However, consideration is being given to whether it might in some cases be possible to amend the provisions to limit the scope of the powers so that they can be more clearly understood to be for the purposes that are within the legislative competence of the Scottish Parliament. Yes.
I can't see why it could be a Section 30 for the outstanding provisions beyond the medical resources. I mean, she could do that. This is a fail-safe. But there's absolutely nothing wrong with what the Chair of the Scottish Affairs Committee requested, which is some sort of draft order, so we can see specifically what would be included, which would at least give some sort of comfort to MSPs who are considering this bill.
And officials of both governments are indeed working through a range of scenarios, but what we can't do is table an order about a bill that has not been passed. So there are ongoing discussions, as you would hope and expect, but as I say, we cannot use a Section 104 order until a bill has received royal assent. Now, the Chair of the Scottish Affairs Committee has asked for clarification on whether the Scottish Parliament would be able to amend or repeal the Act's regulation-making powers in a future Scottish parliamentary session, and I'm pleased to clarify. If the bill is passed and contains regulation-making powers authorised by the Section 30 order, it would not be possible for the Scottish Parliament to amend or repeal those regulation-making powers in a future session. The time limits within this Section 30 order mean that it would no longer be within the Scottish Parliament's legislative competence to do so. Instead, subject to the Secretary of State's approval, they would be able to revoke or amend the regulations that have been made under those powers. And could I also just take a moment to answer the question that the Chair has raised about whether there wasn't whether we didn't receive a copy of our response to their report in a timely fashion. We have responded, and I'm grateful to the committee for submitting it, but her points about timeliness and courtesy are well taken, and I'll ensure that courtesies are observed in future. So we were asked by the Honourable Member from Perth and Kinross, and it's come up a number of times in the debate, about whether the UK Government would consent to a future Section 104 order request. And we do understand that the Scottish Government will seek the agreement of the UK Government per the correspondence with the Scottish Parliament from the Scottish Government. We do understand that the Scottish Government will seek the agreement of the UK Government if after the bill has passed, and that will ensure that practitioners are protected should they choose to opt out of an assisted dying service, and we expect to agree in principle to take forward that order, but they will be considered in the usual way once we have actual legislation to look at. The Honourable Member for Perth and Kinross also raised the point of whether in effect failure to pass this order today would have the practical effect of stopping legislation progressing in the Scottish Parliament, and that is our view, that we have to pass this today in order to give practical expression to whatever choice the Scottish Parliament, and it's indeed their choice to make, but whatever choice they make, we believe it is our constitutional responsibility to facilitate the progress of legislation through the Scottish Parliament. There have been a number of questions raised about the justification for a time limit in the order, and our view is that the time limit reflects two things. Firstly, that this is not a permanent, perhaps to his displeasure, it's not a permanent alteration to the devolution settlement, and secondly, that it wouldn't be appropriate to preempt consideration by any future Scottish Parliament and attempt to bind them in that way. The Section 30 on an independence referendum illustrates that actually there is a precedent for including a time limit in a Section 30 order. So we've concluded that it's appropriate to provide for temporary and temporary only devolution of legislative competence in a Section 30 order, because it's seeking to address a very specific issue. And this is where I would like to close. The matter before us today is considering a very narrow and technical order which provides the Scottish Parliament with a time-limited ability to include powers in the bill to identify and regulate substances and devices which could be used in an assisted dying regime. It is important to be clear that this order enables the Scottish Parliament to do this if it chooses. It in no way compels it to. The decision on whether to create an assisted dying regime in Scotland remains, as it should be, a decision for members of the Scottish Parliament. So while the Government remains neutral on assisted dying, we do believe that the approach that we've taken with this order is appropriate, and on that basis I beg to move.
The question is, the committee have considered the draft Scotland Act 1998 modification of Schedule 5 Order 2026. Does many of that opinion say aye? Aye. On the contrary, no? No. Division. Are you happy to close the vote? Happy to close the vote?
Yep.
Sorry, just before you start, just for clarity, I just mentioned that the Chair of Scottish Affairs Committee doesn't have a vote in these particulars.
Andrew Bowie?
No.
John Cooper?
No.
Deirdre Costigan?
Aye.
Harriet Cross?
No.
Bobby Dean?
Aye.
Josh Dean?
Aye.
Alan Gemmell?
Aye.
Damia Griffith?
Aye.
Lloyd Hatton?
Aye.
Sir Mark Hendrick?
Aye.
Kirsty McNeill?
Aye.
Susan Murray?
Aye.
John Pearce?
Aye.
Peter Brinsley?
Aye.
Camry Tufnell?
Aye.
Pete Wishart?
Aye.
Daniel Zeichner?
Aye.
The ayes are 14 and noes are 3, so the ayes have it, the ayes have it. Unlock. Order.